Greetings, everyone. Welcome to the DC Bar Pro Bono Center's webinar, Intellectual Property Essentials, How Businesses and Entrepreneurs Can Identify, Protect, and Profit from Their Innovation. I'm Daryl Maxwell, a managing attorney here at the DC Bar Pro Bono Center. Let me first thank my colleague, Kelly Keller, who is also an attorney and whose practice is focused on domestic and international trademark clearance, prosecution, enforcement, and portfolio management for clients in a wide variety of industries. Let me thank her for kindly taking the time to do the second of our series on intellectual property. Kelly's a graduate of Pennsylvania State University and the Catholic University of America, Columbus School of Law. Let me also thank Mary Ann Lombardi, Chief Creative Economy Officer for the District of Columbia Office of Cable, TV, Film, Music, and Entertainment, for co-sponsoring this series. Before we get started, I'd like to go over a couple logistics for the webinar. First, just so you know, this webinar will be recorded. It's being recorded right now. There is also a PDF copy of the webinar slides in your dashboard that you can refer to during the webinar. Once we're done, if you'd like to recommend the webinar and presentation to a friend, you'll be able to pass that information along through our resource site, www.lawhelp.org/ec/CED. I'm sure you'll have tons of questions. You will ask those questions on our dashboard. I will make sure to pass them along to Kelly at points in the presentation that make sense. In our last presentation, we talked fairly generally about intellectual property, some of the reasons it's around to protect you, some potential pitfalls, but we spoke very high level on intellectual property. Today, we're going to be talking a lot more specifically about trademarks and trademark applications. We have a lot to get to, and Kelly, I know, is ready to go, so I'm going to turn it over to you. And again, like I said before, if you have any questions, I will make sure to take them down and pass them on to Kelly as we go. Kelly, it's all yours.
Super. Thanks, Daryl. I'm so excited to be here, and thanks all of you for dialing in and watching today. And I hope this is a productive and instructive time for us together. And let me just make sure that I am able to advance my slides here properly. For some reason, I am having a difficult time, so bear with me for just a moment. There we go. Okay. Excellent. Okay, well, as Daryl mentioned, my name is Kelly Keller, and today we're actually going to walk through trademarks through a series of 9 lessons that are really aimed to teach you the basics of what trademarks are, why they matter to your business, and how to get started in choosing and registering marks for your business. And again, bear with me, I'm having a difficult time getting these slides to advance for some reason. There we go. Okay, so let's get started with lesson 1. The learning objectives here are to understand what a trademark is, to be able to differentiate between the types of trademarks and what can be trademarks, and to be introduced to the relevant laws that affect trademarks. So let's get started here. A trademark is any letters, words, or symbols, or a combination of any of these elements that are used to identify your business as the source of goods or services. A trademark tells consumers and the marketplace that any product or service bearing your registered mark comes from your company and not from any other source. Trademarks must be unique. They protect your company's brand name and the brand reputation associated with its products and services. They protect against misrepresentation of the source of the products and services. For example, when counterfeit iPhones were distributed to the marketplace some time ago, Apple quickly acted to reinforce its trademark rights. Those counterfeit iPhones were unlikely to have the same level of quality as real iPhones bearing the Apple trademarked brand and logo. So if those counterfeit iPhones were distributed to wider audiences of consumers, you can bet that the Apple brand image would be greatly tarnished because people would be like, well, all of a sudden Apple's not making quality products. As the trademark holder to the iPhone shape, the Apple logo, and the iPhone brand name, Apple has the right to stop, indeed I would say responsibility to stop the manufacturing and distribution of counterfeit products. So similarly, imagine if another company began advertising and selling products using the same name and logo that your business uses. Now imagine that the other company's products are poor quality. You wouldn't want consumers to be confused and assume that those poor quality products came from your company. It could absolutely ruin your business. However, if you had trademarked your brand name and logo, you could protect them and bring legal action against the company that infringed on your rights as the trademark holder. Without a registered trademark for your brand name and logo, you'd have little chance of stopping the other company. And let me qualify, you'd have a much more difficult time in stopping the other company. You know, bottom line, trademarks are intended to eliminate confusion in the marketplace. If you don't take action to secure your intangible assets that can be trademarked, you're opening your business to massive risk in the future. Before we move on with this lesson, I'd like to point out that a service mark is the same thing as a trademark, but it identifies and distinguishes the source of a service rather than goods. Throughout this webinar today, the words trademark and mark will be used to refer to all types of trademarks and service marks. So for example, a trademark would cover products like clothing, shoes, vehicles. A service mark would cover things like telecommunication services like that you'd get from AT&T or Verizon and so on and so forth. So let's talk about some examples of what can be trademarks, such as names, symbols, a combination, and slogans. You can apply to trademark a variety of elements through the U.S. Patent and Trademark Office. The most common examples of what can be trademarked are displayed here on the screen. They're names, symbols, a combination of names and symbols, and slogans. So some examples of trademark names are Coca-Cola, Nike, McDonald's, and AT&T. It's important to understand that a business name and a trademark name are not the same thing. So Nike, for example, is the name of the business name, and Nike is also the name of the trademark name. But for example, some companies, like Microsoft, for example, owns the Skype brand. So Microsoft is the name of the business, but Skype is the name of the trademark. We'll learn more about this distinction as we proceed, but for now, consider this example. I just gave you a couple of them, but here's another clarification. Procter & Gamble, for example, owns a variety of trademarks that represent brand and product names like Tide, Crest, Bounty, Gillette, Duracell, and many more. And interestingly, most of us really don't understand or really care who owns particular brands. What we care about is, do we actually trust that brand, and do we understand that brand to be representative of a product that actually makes sense to us and something that we'd actually like to buy and to have. So you can start to see the importance of just the trademark itself. It represents the brand promise. So we're connecting with the brand, not necessarily the name of the company. When you walk into a store and you see, oh, okay, I'm going to look at batteries and I see Duracell batteries, you're going to have an assumption that whoever manufactures Duracell batteries is actually doing a good job. Whereas, you know, there's things that I want to buy, but you may see an off-brand and not know. The fact that Procter & Gamble actually manufactures them is not as important to you as the fact that you just trust the brand itself. Okay, let's continue to move along. Daryl, my apologies. I'm having a little bit of a difficult time advancing the slide today. So just hang with me.
No problem.
Okay. Continue here. Magic. Well, there's also some less common trademark types that I'd actually like to mention so that, you know, for your sort of situational awareness so that you understand what they are. And it's kind of a fun fact about trademarks. So in addition to commonly trademark names, symbols, combinations, and slogans, you can also trademark colors, shapes, sounds, and scents. the process for trademarking these less common elements is a little bit trickier. We'll go back. Now we got a little bit excited there. But with the right help, you can do it. So here's some interesting examples. Some trademark colors include brown for UPS, Tiffany blue, and the Coca-Cola red, and even pink for Owens Corning's fiberglass. If you've ever done any construction project and you see fiberglass that you're actually installing that's pink, that color is actually part of a brand. So the idea, like if we think about UPS, when you see, you know, a brown UPS drive by, even if you don't see UPS itself on it, you know immediately that that's a UPS truck because you recognize the brown. So the consumer recognition in the color and association with the product and service is also something that you can secure exclusive branding rights in. Same things here with shapes. So we look at the Coca-Cola bottle. I mean, you can spot that from a mile away. And if you notice, even today, the plastic bottles mimic what the original glass bottles look like because that's an important part of consumer recognition. I really like the goldfish, and then of course there's the iPhone as well. Sounds, the NBC chime. It's the like this. I will spare you actually trying to illustrate it, but it's the three-tone chime, Intel startup chime when you actually start up a computer, or MGM's lion roar, which is, and also if any of you are Law and Order fans, it's sort of that don't sound that every time they do a major scene change. That's actually a trademark as well because it's something that consumers specifically associate with a particular product or service. For those of you who are motorcycle fans, the Harley Davidson exhaust sound, that's actually a trademark as well. Well, scents, interestingly, are also trademarkable in some contexts. They are the most difficult element to trademark, and I think it wasn't until about 1990 that we had our first scent trademark registered with the U.S. Patent and Trademark Office, which was for a flower smell for yarn. It's since been canceled because I don't think the owner actually renewed it, but it actually, you know, created a precedent. Manhattan Oil has a trademark registration for a cherry scent for synthetic lubricants, for high-performance racing and recreational vehicles. And I think most recently there was a registration for the scent of Play-Doh. How many of us actually played with Play-Doh when we were children? So you can see that big companies who are trying to distinguish themselves in the marketplace are looking far beyond just words and symbols, but also for other sort of distinguishing elements. And that's important for you to know as you're building a business, that if you end up creating a lot of brand significance in one of these non-traditional elements, that's something that is possibly open to you as well. It also gives you the chance to say, hey, you know what, I need to make sure that I am not infringing on those types of things. So if I wanted to go into the business of, you know, sort of Play-Doh manufacturing, you have to make sure that you're not copying the scent. That might be kind of a far-reaching example, but you get the gist. Let me just give you kind of a quick snapshot so that you understand there's kind of a range of laws that govern trademark. It's not just one simple law. There's a lot of different tentacles, and it's important that you understand that it's far-reaching, and that's a positive thing, is that there's a lot of different ways to protect your brand and to enforce your brand. It's not just through the standard trademark law itself. But just as a quick review, the Trademark Act of 1946, we call this the Lanham Act. So if you ever hear that term, the Lanham Act, that's the core trademark law that we operate under in the United States. That's your starting point, but we also have various state laws that are unique to each state. Those can affect trademark protection. And then we have specific laws and regulations that can affect trademark protection online, including the Anti-Cyber Squatting Consumer Protection Act and the Uniform Domain Name Dispute Resolution Policy. Obviously, those are long, complicated names, but here's the bottom line. What the Anti-Cyber Squatting Consumer Protection Act is going after is for people who want to buy domain names with famous trademarks in them, and then they want to sit on them or squat on them and try to extort a lot of money out of somebody for purchasing them back. Because when you're trying to build brand significance online, if you're not able to get the domain name with your trademark in it, or somebody else is using a domain name with your trademark in it and they're competing with you online, now you can see you actually have trademark infringement there. It seems a little bit non-traditional, but it's a really big deal. And then the Uniform Domain Name Resolution Policy, we call it a UDRP for short. That's a way if somebody registers a domain name with your trademark in it, it's actually a legal process to get them to get a court order for you to get that domain name back. So that's different than traditional trademark infringement. So while this is a little bit more on the legal side, it's important just, I think, to give you an overall orientation about the complexity of it. So that wraps up the end of this lesson. So why don't we move on to lesson 2 and talk about real trademark problems. But let's review our learning objectives, and they're to identify the potential problems if you don't secure your trademarks, understand the business value of a trademark, and understand the role of employees or just your team members in protecting trademarks. Sometimes if we're just starting a business and we're a solo, just a one-man band or a sole proprietor, we may end up having a designer or somebody who's contributing to helping us. They're not actually an employee, but they're a team member. So just because you don't have a big company doesn't mean that you don't have people who are supporting your work. So I want to use this real trademark problem, a real example, and this is something that I think is kind of interesting and a fun fact, so you can get a sense how just a small company and a small creative professional can wind up in some hot water over their use of a particular trademark, or in this case, of an actual shape. So here's an example that we have up here on the screen. Some of you may have heard about DJ Deadmau5. He's a Canadian DJ, kind of like electronic dance stuff, those types of things. And interestingly, his onstage costume consists of this sort of mouth-looking headset, or head cover that he actually puts on, and you can see where the eyes and the mouth are. But it's these ears that mimic, or allegedly mimic, the Mickey Mouse ears. Well, DJ Deadmau5 has actually had a lot of international protection all over the world for its the shape of his sort of headgear costume. And when he tried to get protection in the United States, this was a few years ago in 2014, Disney had a problem with it and objected to the application. And in true Disney fashion, they filed like 171 page complaint about why they didn't think that DJ Deadmau5 should actually get trademark protection for the shape of these ears for his particular DJ services. Well, it's interesting because instead of backing down, even though DJ Deadmau5 is a much smaller entity than the Goliath of Disney, I think he actually put out a tweet after the lawsuit was initiated, all right, lawyer up, Mickey, because I'm coming for you. Well, about a year later, they ended up settling the suit out of court for an undisclosed term. So we're not sure what exactly happened. But, DJ Deadmau5 just is coming and using what he's been using all over the world here in the U.S. and wound up spending a huge amount of money to defend his rights. And I think that the way they settled out, he's able to continue. But it just gives you an idea of you may not be, you still may be very small, and you may not think that what you're doing is problematic to somebody else. But when you have a big company that is spending a lot of resources checking out even what small businesses and newcomers are doing, you may find yourself in hot water. So it's important to really understand what you're doing before you move forward with trademarks. And that leads us right into the concept of researching your trademark before you start to use it. You just want to make sure that you have the absolute right to move forward with the particular trademark that you're trying to adopt before you put a lot of investment in it. Essentially, your full business is at risk if you don't protect your trademarks, because what would happen is if you adopt a trademark, somebody else sues you, you don't have the resources to fight, and they shut you down. So when I'm not being dramatic in all sense, if you do not have a trademark that's yours to use, and that somebody else isn't already using, or that's so close to somebody else's, it can actually have dire consequences. So, you know, I'm not trying to be overly dramatic here, but I do want to just, you know, really emphasize that importance, because it's not just about something that you can use that other people aren't, but something gives you the chance to own your distinction and to be unique and different in the marketplace, which is part of your own competitive advantage. Well, I think that here's a display of some of the expenses that you might have to incur if you end up having to rebrand. Tell you a quick story. A client of mine, a small jewelry store in a strip mall. So basically, she is a jewelry store selling third-party branded products. So she may sell some David Yurman stuff or John Hardy stuff or other jewelry designers. She doesn't actually make and sell jewelry herself. Well, when she launched a Facebook page several years ago, there was a jewelry company out in California, and this is, you know, I'm here on the East Coast and they're out on the West Coast, that actually owned the trademark for her company. So her business name was Fire and Ice Diamond Gallery. And there was a company out in California that owned the trademark for Fire and Ice for a specific brand of diamond. So they had a diamond that they would cut using certain techniques, etc. So the idea was that the diamond was, you know, shiny, and it was like kind of the look of, quote, fire and ice. Well, remember, they're creating a specific gemstone. My client's in a small strip mall just offering third-party products, not anything under the name Fire and Ice, but her overall store. Well, this company out west ended up suing her for trademark infringement, and she had no idea because she didn't use any trademark help before she actually started her business, and she ended up having to rebrand. So when we look at here, she had to get all new product packaging because, you know, every time you buy a piece of jewelry from her and, you know, let's say you go in and you get a ring and it comes in one of those little ring boxes, it would have Fire and Ice Diamond Gallery on it. Now she had to change the name, and so she had to get all new packaging. She had to pull all of the any particular products that were offered under the Fire and Ice Diamond Gallery name. She had to change all of the signage, pay legal fees and fines. She had to pay a hot penny to negotiate the settlement, and it was a pretty tough payday for her, or I should say lack of payday. She had to rebuild brand awareness and trust, and recreate marketing and advertising, so a whole new website, whole new social media, et cetera. So somebody who had been in business for about 6 years and then overnight you have to change everything, it's just not worth it. So I think it's really important to invest up front in making sure that you are choosing a trademark that's available for you to actually use and for you to be able to grow with. So I mentioned here, to choose a trademark you can actually protect. And what I mean by that is that the trademark has to be available for use and available for registration. We'll move through that here as we proceed through the lessons, but the high-level takeaway on this is that a trademark has to be available for use, meaning that there isn't somebody else out there that's already using the same or similar mark for the same or similar services. So that means that if somebody's using it, use is king in the United States. Whoever uses the trademark first wins. Now, without a federal registration, we call those common law rights. They're not registered rights, common law rights. So the common law rights can be enforced. Even if you don't have a registration, they're a lot harder to enforce. But if you're somebody who comes along and files a trademark application, you know, in May of one year, and then somebody else comes along and files one in August, but they used it before you, they can still trump you. So it's important to know if there's somebody out there who's been using a trademark before you actually proceed with it. And then is it available for registration? What I mean by that is, does it meet the qualifications of a registered trademark for the United States Patent and Trademark Office? And what that means is that it actually is what we would call a protectable trademark. in that it is not a descriptive term, it's not a generic term, but it is actually something that can function as a source identifier. We talked a little on the last webinar, and we'll get a little bit more into what a protectable or a strong trademark here is in just a couple of seconds. So I'll save getting into that detail here in a few minutes. But those are the two key pieces before adopting a trademark. Is it available for use, and is it available for registration? Well, let's look here at what you get with a trademark registration. And what this means is that you have filed an application with the U.S. Patent and Trademark Office and that you have secured a registration. That means it's a federally registered trademark. So essentially, this is what the summary of benefits are. Only once you have a federally registered trademark can you use the registration symbol. So this circle R is reserved only for registered trademarks. You cannot use it if you do not have a federally registered trademark. Along with this registration, you also are able to get, once you have this federal registration, it gives you enormous protection against registration of other confusingly similar marks. So if you get a registration and somebody wants to come along with something that's sort of the same or similar to what you're doing, if you have a registration, the trademark examiners, when they are looking at a later filed application, they're going to search the database, and when they see your trademark registration, they're going to actually block the later application and say, hey, listen, you can't have that trademark because there's somebody else who already has one that's similar. So it's sort of a built-in policing mechanism for you, and so that's one of the great benefits of having a registered trademark. Additionally, with a registered trademark, it's much easier to sue. Trademark laws are federal laws, and you have to sue in federal court. So it's a much more complicated situation, and it gives you a much easier way to get into court. You hope you never have to go there, but at least you know in the back of your head. Trademark registrations can be enforced and can be maintained forever so long as the trademark remains in use. So we call that in the law in perpetuity, so perpetually. So it doesn't expire after 10 years if you're still using the mark. So Coca-Cola, we're well over 100 years of use of the mark in commerce. And I think I mentioned on the last webinar that Stella Artois has been in use since like the 1400s for beer. Of course, you know, the United States didn't exist then, but it has been used here in the United States for several hundred years. So the way the trademark registrations work is you have an initial term of 10 years that the registration lasts, and then you have to renew it every 10 years, and you certify the mark is still in use in commerce. So as long as you're in business and you're using the mark, you can maintain that registration. That's different from a patent or copyright that actually both have an expiration date. Just other quick things is when you actually have a federal trademark registration, it gives you certain presumptions. So it presumes the mark is a valid trademark, that you have exclusive rights in it, and that you actually are the owner. So what would happen is, if we use the analogy of a vehicle, if you have a car and you have the keys to the car and you have possession of it and it's sitting in your driveway, you actually have the car. You own the car because you're in possession of it. But if somebody steals it and you don't have the title to the car, it's really difficult to prove that you're the owner. And it's really difficult to prove that you had it. It's basically, you know, a he said, she said. Whereas if you'd had the title to the car, you can say, I had this vehicle, this make, this model, this year with this VIN number on it. So that kind of think of that as the same thing as a trademark registration, where you actually have, it functions like the title to it, and it comes with a lot of clarity and a lot of business, and a lot of other benefits, excuse me. Well, I think something else I want you to take away is the business value of a trademark. I mean, it's a really, really big deal. I really think that for most companies that the trademark is absolutely the most important asset you have. Because if you lose your rights in your mark, or if you start to gain a bad reputation, people are going to associate it with a brand name, not really with anything else. And that goes for huge corporations and for tiny businesses as well. I mean, if we think about, you know, what does a trademark really represent? It's the quality and the reliability of a company's products and services in the consumer's minds. So like based on their experiences with the products and services that bear your trademark, you know, your customers or consumers will develop expectations for any product or service they encounter in the future that has your mark on it in association with particular goods or services. I mean, your entire commercial identity and reputation is wrapped up in your trademark, or what we call your trade identity, which could also include a design element or colors or things like that. And it represents your goodwill, your reputation. It represents the investment in advertising, the ability to command certain prices, consumer loyalty, and more. I mean, I think about there's a series of Farmers Insurance commercials that air now, and it's hilarious because, you know, they have the "We Are Farmers," the actual tagline, and I know it in my head, I know it all the time, and in my mind, I keep seeing that advertisement over and over, and it makes me think, boy, they are investing a huge amount of money in advertising. They really believe in what they're offering. They believe that it matters, and they believe that it is, you know, a good product or a good service. And so just by seeing the advertisement, it makes me have a certain impression in my mind about them without having actually patronized them, just from their branding and their commitment and their investment in branding. Well, I should tell you that brand value, when we talk about brand value, Apple and Google have consistently been number one and number two in terms of global brand value. And there's a company called Interbrand that actually measures this. And in 2017, Apple's brand value was estimated at $184 billion and Google's at $142 billion. Just the brand value in terms of all of those elements we talked about: goodwill, reputation, investment, and so on and so forth. So while a small business isn't going to achieve that overnight, both Apple and Google started as teeny tiny businesses, you know, one-man bands. So while this is something I just want to mention so that you have this, kind of at the top of your mind, when you start to build a company, requiring your team members to respect your brand and understand how to use your brand is going to be an important part of growing a solid company. So it's something that even just as you're thinking now about getting a trademark, it's so important that it will be an important part of managing your company as you build it, whether that's with 1 employee, or, 100 employees, or 10,000 employees. Okay, so moving right along, let's talk a little bit about the difference between trademarks and trade names. This is kind of getting your business name. So if you're in DC, it's registering it with the District of Columbia, forming like an LLC or a corporation, versus your trademark. And I just want to highlight this quickly so that you understand this as you're going into business or as you're starting to build your business, because it's a really important distinction and one that can trip a lot of people up if they're not careful. Okay, oops. So Daryl, I couldn't get the slides to move forward, and now I'm trigger happy here. Okay, so trademarks and trade names.
Right through them, yeah.
All right. Hey, this is live TV, people. Okay, so a trade name is the name that you're doing business under. So that would be like my company is the Keller Law Firm. I'm the Keller Law Firm, LLC. That is my official corporate name. That is the name that when I formed my company, that is on the name of the official corporate documents, and it's the name on my tax returns, it's the name on my bank accounts, and so on and so forth. It also happens to be the name of my trademark. The Keller Law Firm is how I do business with the public, so my business name and my trademark are the same. However, sometimes the business name and the trademark can be different. Like a perfect example here, we all know what Tylenol is, but very few of us know or care that it is manufactured by Johnson & Johnson. We all know who Nike is, and we all presume that it is manufactured by, or those products are offered by Nike Inc. So that's where you can see kind of like me with the Keller Law Firm, I'm the same as like Nike and Nike Inc. But Tylenol is a brand name, but their business name is Johnson & Johnson. Why do I mention this? I mention this because business names are governed by state law. Trademarks are governed by federal law. So if I am the Keller Law Firm organized under the laws of Pennsylvania, it only matters that the name the Keller Law Firm is available in Pennsylvania for me to use as a business name. Somebody in Virginia, somebody in D.C., somebody in Maryland, totally separate entities could also go to their respective departments of state and form the Keller Law Firm LLC, because that means that they're able to operate that company in that particular state. However, if they want to go online and start promoting their brand nationally, and, you know, for all intents and purposes, the minute that we put our brands online, we're actually promoting them nationally. Now you're dealing with a brand name and a trademark. And if I'm first, and I'm the first one to use my trademark online and offer services around the country, which I do, well, then the later comer in Maryland or Virginia or D.C. or California, Wyoming or Florida, it doesn't matter, could not actually use that as a trademark. They can only use it as a business name. So when we're adopting names, we need to clear them for use as a business name, but also as a trademark. And that's where getting a little bit of legal help really, really matters. So here's a quick little overview of what I just explained, that trademarks and trade names, they're not the same. They're handled by different agencies, and they use different approval criteria. So for example, the Keller Law Firm in Pennsylvania, where my business was formed, if there's somebody that wanted to come along and call it the Keller Law Firm, just plural, because there was an S, there was at least just one character difference in the name, Pennsylvania Corporation Bureau would say, hey, no problem, because they're just looking at business names being different enough so they can index them. They're not looking at them for trademark purposes or likelihood of confusion. So that's a really important point that I want to drive home, because I call this an early decision and an early mistake, choosing what to name your business and how to brand your business. And it's a big deal that you want to get right from the outset. Okay, moving right along. Yep.
Can I jump in? I have a couple of questions.
Sure.
So the first question is, for a business that may be operating both here in the States and internationally, what sort of protections would you have to seek out? I imagine it's sort of country by country distinction depending upon where you're operating. But if you're operating both in the United States and in China and all over Europe, what sort of protections would you need, or could you even look into to make sure you were protected?
Absolutely. From a trademark perspective, you're right, Daryl. Trademarks are what we call territorial. So that means that they're only protected in the country or what we would call jurisdiction where they are registered. So a trademark registered in the U.S. With the U.S. Patent and Trademark Office is only enforceable in the United States. If you're a U.S. company but you're also doing business in Europe, then you can secure trademark protection in Europe. And they happen to have, you have the European Union over there, so you actually can file one trademark office with the one trademark application with the European Trademark Office, and get a registration in all 28 member states. China is its own separate jurisdiction, so you would need to apply to get trademark protection in China exclusively there. There are two ways you can pursue international trademark protection, and one of them is kind of going on a country by country or jurisdiction by jurisdiction basis, filing in each of those individual trademark offices, and that usually works by you having a U.S. application, and you have a U.S. attorney who's been coordinating with foreign attorneys on your behalf. And then another way to do it is there's a whole separate system called the Madrid Protocol, and that's just named after this treaty that was signed that created this system, where you have this what's called an international registration, where you get this registration. You have to have your home country registration, so that you start in the U.S. and you get this international registration, and think of it like a bicycle wheel. you can then take that international registration and add countries or jurisdictions to it. So it's like you're extending protection. Say, okay, I've got an IR and I'm going to extend protection to China. And then I'm going to extend protection to the European Union. 5 years from now, I start doing business in another country outside of Europe, so I'm going to extend protection there. So there's these two different avenues, and it's much easier to get international protection than it used to be, but it's also a complicated and dicey process, so you definitely want to do that with Trademark Counsel. That's a great question. Is there another one?
Yeah, although I think it's kind of similar. It's just, and we get this quite a bit, where clients will come in and have, their questions are about making sure a trade name is available in a couple, let's say there's, they're operating in 2 or 3 different jurisdictions here locally. It's DC, Maryland, Virginia.
Yep.
Maybe a trade name is available in one, but not all 3. But then, the name that they're looking to register their trademark is available. Sort of what would you advise in that case, where they can find the trade name and sort of matches up with the trademark they're looking to obtain, but it's not available in every single jurisdiction they might register?
Well, I think that it doesn't matter so long as that you're able to, meaning the trademark is the most important thing. So long as the trademark is available nationally, that's what matters the most. Then you file your corporate documents in one state or in the District of Columbia, and if you're doing business, like legitimate business activity in other states, such as you need to register to do business there, and if your name is not available there, then you can adjust your name enough to be able to qualify under that state's laws for doing business. So it's essentially, just because you're doing business in the District of Columbia, if in 10 years from now you need to qualify to do business in Arizona, but there's somebody else under the same exact name, you can tweak your name. So, and that shouldn't affect the public-facing brand. So, and that's something, is that making sense? So it's really the public-facing brand that's national protection is the most important, and then you can just adjust your business name along the way, because that's not what the public needs to see. Does that make sense?
That does. I've got one more question for you.
Sure. This
one just came in, and I think I know the answer to this, but it's if someone is using the name, using the name that a business owner is interested in, can you add a modifier in front of the name in order to trademark it? I'm going to guess no, but please, you're the expert on this.
Well, I think that as a general rule, the answer is generally no. And the reason is this, that the standard of trademark infringement is likelihood of confusion. So what that means is if all of trademarks are from the perspective of the customer. So if the customer is looking at 2 trademarks, the original trademark and the one that you just added a word to, is a consumer looking at them likely to believe that whatever the branded products or services are from those various trademarks, do they emanate from a common source? And a lot of times, the answer would be yes, because if we have, let's say that we have, we can even just take iPhone, for example, the I trademark. If you have I and then you have iPhone, then you have iPad, and you have iPod. So we start looking at the significance of that I, and we start to associate it with Apple. So if you take iPhone, and then in front of it you wanted to put some other distinctive word, like, happiness iPhone, everybody's going to assume that that's a new product from Apple, because that's the trademark that they understand. So just adding words to them generally doesn't distinguish them sufficiently in the mind of a consumer, especially if they're in the same line of product or service. Coming up with something more distinct and different is generally going to be the right move. Another misconception that frequently happens is people think that adding like a descriptive or generic term at the end of a trademark will actually distinguish it. So let's go to my client, Fire and Ice Diamond Gallery, and I should mention that I have a full release from her, so I'm not disclosing any information that I shouldn't be. But Fire and Ice Diamond Gallery, in one of the things is, you know, like, well, can I just be like Fire and Ice Diamond Gallery of Carlisle, Pennsylvania? No, that's not enough to distinguish it, because just adding a geographic term or some kind of just descriptive term like Fire and Ice Diamond Gallery Jewelry Store, something like that, like jewelry store, it's not a trademark, it's just descriptive generic wording, that doesn't make it different enough under the trademark law. So that's a misconception. It's a really good question, whoever asked that. Well, let's cover, moving forward, what it means to have a distinctive and a protectable mark, and I think this actually dovetails nicely with the questions that we actually just had. So picking a strong mark that's actually protectable, you know, we had talked about use and we talked about registration. So in order for a mark to be registrable and protectable, it has to be what we call distinctive of the underlying services. So that means that the trademark itself does not actually describe the products or the services it represents. It's distinctive. If it's descriptive, then it actually does. So if we take a look at this slide here, if you see the sign out here, out in the front of the store that says, the thing you use to type stuff and do other stuff with the screen and a keyboard store. If that's literally what the name of the store was, it's the thing you do to type stuff store. That's descriptive. It tells you exactly what it does. This is a, you know, kind of a bit of a stretch of an example, but that's being descriptive. Whereas if it was Best Buy, then that's actually the name of the trademark, if that makes sense. So you want to have trademarks are distinctive. They don't actually describe the actual product or service that is being offered. Okay, just a moment, and just a minor pause and delay here. Okay, come on. Okay, we're trying to get this to move along. Apologize. There we go. Okay, let's just run through this very, very quickly because we did touch on it, and I still want to make sure that we get to the pieces of the actual trademark application itself. So when we talk about distinctiveness versus descriptiveness, essentially trademarks that are distinctive are protectable, trademarks that are descriptive generally are not. So if we look at distinctive marks, they are marks that are made up. They're marks that are arbitrary or suggestive. So what that means is that a coined or a fanciful term, such as, I have some examples that are going to come up right here. A coined or a fanciful term is one that is completely made up and does not have any other meaning than that as a trademark. And they have the highest amount of protection. So like Google, Exxon, Clorox, Kodak, these words mean nothing else. So if somebody else tried to infringe on them, it's very clear that they're trying to trade on the trademark. The next level of really strong trademarks, and this is important when you're thinking about naming your business and your products, are real words used in an arbitrary way. So Apple for computers, the word Apple means two things. It means the fruit, but it also means the name of a business. Those are very protectable marks. And suggestive marks are those that actually kind of have a clever twist to them. So it takes the consumer sort of a moment to say, oh, I understand what that means, but it just kind of gives a little bit of a hint of what the underlying product or service is, but without actually describing it. So North Face is a great example that I have here because, you know, when we're talking about outerwear and the North Face of the mountain is the coldest side, so we want to have things that are going to keep us, you know, warm from the cold. Weak marks are much less protectable, are far less protectable. They're very, very difficult to enforce. So, for example, if you have a trademark that's descriptive, and that means that the trademark, when applied to the goods or services that it's being offered on, if it actually describes them in any way, or like a feature or an ingredient or a function of them, we call that a descriptive mark. And it's not protectable until it acquires distinction. That means that I mentioned Best Buy. Everybody knows that Best Buy, it's sort of a colloquial term for the best buy in the business. Well, Best Buy for a consumer electronics store, by consistently using the trademark over time, it gained what's called a second meaning in the marketplace. So now everybody knows that Best Buy is a sort of a short phrase for a bargain. It's also the name of a consumer electronics store. Essentially, through continuous use and market recognition, what we've done is gotten to the place where it's functioning almost like an arbitrary mark. Like Apple has two meanings, a fruit in the name of a computer company, whereas Best Buy now has two meanings as well. So that's kind of what we're trying to achieve, is that level of distinction. If you do not have a distinctive trademark, it's not registrable with the United States Patent and Trademark Office. You're welcome to use the term, but you won't be able to get any protection or stop other people from using that same non-distinctive term. And of course, generic names here are never protectable. So I'm going to kind of quickly move through this so that we can get to the trademark application piece in our last section here. You just get a visual representation that the stronger your trademark, the more protection you have. You know, the stronger your mark, the bigger your moat, and the deeper your actual moat. So we're going to talk quickly here about what a trademark search is so that you understand that, and it's important, and then we'll go to the registration process. A trademark search is extremely important to conduct or have somebody conduct for you so that you know whether or not you can actually use a particular trademark. We talked throughout this particular presentation about common law or unregistered rights. Who was the first person to use a trademark? If somebody has used it first, then they can stop you from using it in that same geographic area where they're using it. So if you have somebody in, you're in DC and there's somebody out in Idaho, and they have the business name and maybe they're operating under that same name as a trademark out in Idaho, but only in Idaho, but they haven't, or maybe in, a few states in out west, maybe they haven't filed a trademark application, so they don't have registered rights, but they actually have common law rights based on use. So they could preclude you from using the same or similar mark in that geographic area. Well, you're going to want to know about that before you adopt a trademark that you intend to secure national rights in. You're not going to find that with the Trademark Office because they haven't filed an application. So just searching the PTO's database isn't going to reveal that. But that is a use that could preclude you from adopting that mark and having sort of, a clear way to move forward in the marketplace. So I want to raise that without getting too deep into the technicalities of just how important it is to conduct a trademark search and to have somebody who understands what they're doing to actually do that on your behalf. I'm a big, big fan of knowing when to DIY and when to not DIY, but to actually get some professional help. You'll be able to look at this in a little bit greater detail after the webinar if you want to download these slides, because I give you a little bit of guidance on whether or not you should use a legal document service provider like a LegalZoom or do it yourself, or if you actually want to use a professional trademark attorney. And remember that trademark law and intellectual property law is extremely specialized and it's relatively complicated. So somebody who's a general business attorney, not specifically trained in this area of law, sometimes may not be the best fit. And most of them will tell you that's not what I'm trained in. So you want to think about getting the right help in the right way before you adopt a trademark. Okay, you get what you pay for, right? Okay, and I'll just move through this so that you get an idea. This is going to take you through all of the various steps that you get when you actually use a trademark attorney. So we'll move through this and then get to the application process. And then I'm happy to stay on the line as long as we need to answer questions. Okay, so you can see all the different pieces of what the trademark attorney is going to search, and they're going to interpret all of these non-registered uses so that you can understand whether or not this mark is actually legally available for you to use in commerce and whether or not it's available for you to register. It seems like a bit of an investment, but it's one of the most important investments that you'll make in your business. And, you know, in the end, if you choose to go it yourself, that's fine, but do it having understood, understanding what the risk is and what the risk tolerance is before you actually move forward. Okay. Let's get this up here, and let's talk about filing the application and what those next steps are. Some of you may have already filed an application, and you may have received some correspondence from the U.S. Patent and Trademark Office and not understand it. Some of you may be preparing to file your own trademark application. Let me give you the high-level details of what you're going to need when you file that application. Or if you have filed it but you need to make some corrections. You need to know who is the applicant, who is the legal owner. If you've created a business entity, you formed a company, and and you're doing business with that company, the company is the owner of the trademark, not you individually. You want to make sure that you identify the true applicant of the mark. If you're a sole proprietor, you individually are the applicant. If you have a company, they're the applicant. Then you also have to identify who the contact is. So who's the correspondent? Who is the trademark office going to communicate with on your behalf when they actually review the trademark? If you do it yourself, then you're going to be the correspondent, and some of you may be in this position where you've received correspondence from the U.S. Patent and Trademark Office and don't necessarily understand it, but you're the one who's actually talking to them as opposed to an attorney. If an attorney is representing you, then the attorney will be the correspondent. They're not the applicant, but they're a correspondent. You'll have to file the trademark exactly as you intend to use it. So you actually can file what we would call a standard character mark. That means you're just filing the application without any regard to font or color or stylization. For a small business, this is usually your best option because it is going to give you the broadest protection. The trademark protects the word. You can use it in any color or stylization or font that you would like to. The registration doesn't necessarily protect that unique element of the stylization, but it protects the word. If any of you are Amazon resellers, this is a great option if you want to get onto the brand registry because they need really clean and clear marks, and unless you are consistently using a mark with a particular stylization, they want to see standard character marks. So it's important that you have different options. If you have a standard character mark and then later you want to adopt a trademark or you are using it in a unique way, such as the Coca-Cola script, you'd have to file a new application. You can't just amend your application. You actually have to file a new one. Okay. The next piece of the application is identifying the goods and services. So what will the trademark actually cover? This is really probably the meat and potatoes and the most important part of the application. What's important is when you file an application, whatever you list as the goods or services, you can never expand them in the application. You'd have to file a new application. You can only restrict them or narrow them. So it is extremely important that you get this part right because it determines the scope of your application and how broad the protection is. So if you have a really broad description, you have broad protection. If you have a really narrow description, then you have a much narrow scope of protection. And so I see we're coming right up on the hour, so I'm going to kind of plow through a little bit more here and get to a few of the other pieces, and then we can wrap up if I can take about 1.5 more minutes, Daryl. What's important here is when you're choosing the right classification, so it's not only describing the goods, but you're having to choose the right classification. So there's 45 categories of goods or services that you can choose from, and it's like every product or service is in one of these classes. Well, it's important to choose the right class and the right description. I see a lot of small business owners who who sort of take their own path to try to do this on their own, and they struggle a lot. So if you're just going to get any help with anything, try to get help with the description of goods or services, because it has a huge impact on actual the scope of protection. So we probably can talk just a quick minute here, but Daryl, interrupt me if we need to wrap up. I realized that we really could go about 2 more hours.
No, I think we're good for another 2, and we're good probably till about 1:05, I think.
Okay, perfect. Well, let's keep going, because I think this is really important stuff. So we talked about, you kind of have the application, the description of goods or services, but this is what's really important as well. You can't get a trademark registered until you show it in commercial use, and they want what's called a specimen of use. So they need to see the trademark in use on the product or promoting the service. So what that means is if it's product, like if it's a pair of jeans, you need an actual tag with the trademark on it attached to the goods or in the packaging itself. It can't just be your business card, and it can't just be a brochure. We need to see the product itself bearing the mark or the product packaging bearing the mark. Super important. You won't get the trademark if you aren't clear on that piece. With respect to services, if you're promoting a service, it's not an actual product that you can label, then we need to see an advertisement saying, here's the service, this is the name of the service, this is the description of the service. But the 2 pieces that are important is the trademark exactly as you applied for it needs to be right there, either on the brochure or on the screenshot, in close association with the goods or services, and a way to order them. So the perfect specimen is a screenshot where you've got your trademark in the header, the description of the service that you're offering, if it's coaching services, photography services, counseling services, whatever it is, that you have a description of them, and then contact us for an appointment, schedule an appointment, buy now. We want to see all of that information on one page. That's something that trips a lot of people up. So you want to make sure the trademark, the description of the services, and a way to order them is all in one page. That's super key. And the last piece that you do is you pay the fee and you sign the application. And what's important here is the right person signs the application. If it's you individually, you sign it. If you're signing on behalf of a company and you're the president of the company, you'll sign it, but you want to sign it in your capacity as the president of the company. Let's say you have a partner, and the partner is the president of the company, and if you're not actually an owner, but maybe you work for the company, then somebody who's actually legally authorized to commit the company has to sign the application. We see this as a problem as well when somebody signs, or let's say you're working in the marketing department for a company and you sign an application, or you don't designate yourself correctly. This can be a reason for an application to initially be rejected. So this is more information that you can get on the slides as you download them. Let's just move through this so you can just see some more of the benefits that I set out for you to help you distinguish whether you should do something yourself or use a legal document services provider or an intellectual property attorney, because it's certainly expensive. There's no question that it's expensive, but it's something that's really important. And so we'll wrap up here with what to do, what happens after you actually submit your trademark application so that you understand the process and what happens. And I should mention here as well that in terms of cost of trademark applications, we saw that when we file a trademark application, we include a classification with goods and services. You pay by the class that you include. So if your trademark includes services or products in more than one class, you're going to pay anywhere from $225 to $275 per class. So you have the service fee, whether it's like a legal Zoom or an attorney, you're going to have that fee plus the classification fee. So you want to make sure you get it right because it's not cheap. So essentially when we file the application, It is reviewed by a trademark examining attorney. That's what happens, and sometimes it can take up to 6 months, even longer, for an examining attorney to review it. They're going to review it to make sure that it's acceptable, and if it is acceptable, they're going to allow the application to move forward to what's called a publication process. If it's not acceptable, then they're going to issue an official letter to you and tell you why. And that sometimes is where people get a little confused, and if you are working on your own, it might be a good time to hire a lawyer. But let me just say it goes through examination. The next thing it goes through is what's called publication. What that means is that for 30 days, anybody out there who believes they have superior rights to yours, they can actually challenge your application. That's what happened with Disney and DJ Deadmau5. This is what happens if you have your company out in Idaho or out west, and they're actually using it and they decide you shouldn't get your registration. They can have a chance to oppose. If that is successful, nobody opposes your application, then it will move on to a registration. So if you think about trademarks, and we'll sort of close on this point, that you start with the application and the examination. You may have some back and forth with the examiner about whether the mark is actually registrable. Once we get through examination, we go through publication, which is when it's published in what's called the Official Gazette. It's a government publication available to the public. If no third parties oppose your application, it moves to registration. The process can take up to a year or sometimes longer. You can't be impatient. And many things can happen along the way. So it's a significant investment with a significant asset that you get at the end of the process. And I know that we're out of time here, so I'm happy to stay and answer any questions, or if anybody has any follow-up that they weren't able to ask the question or I didn't address that, please submit them, and I'm happy to provide responses to whatever those questions are.
So, Kelly, I think while we're at time, I certainly agree. If you have additional questions, you can certainly, we'll be sending out a survey after the webinar. So if you have any additional questions, you can certainly email me or in the response to the survey, you know, also add any additional questions that we'll be able to answer after the fact. Let me also say, if you have additional intellectual property questions that you'd like to speak to an attorney with, we have a monthly small business clinic here in DC where you can meet with an attorney for free. We actually have a clinic coming up this evening. I think I sent on the chat information about the clinic that starts at 5 o'clock this evening at DC's Department of Consumer and Regulatory Affairs. Again, if you have additional questions, you'd like to talk with somebody about your intellectual property or any other small business legal needs, you can certainly join us for our clinic. Let me also say thank you very much, Kelly, for providing us with all this great information. I think you may have overwhelmed our group because you answered so many of the questions that they didn't actually have a bunch more, which is great. Let me also say that this is the second part of our series. Depending upon what we hear from you in your surveys, we may come back, and Kelly and I had talked about this before, for a third part of this series, depending upon what your needs and what your interests are. So we will certainly workshop that and possibly come back to you in 2018. Like we said before, this will be available on our resource site, www.lawhelp.org/DC/CED, for you to share with your friends. Let me say thanks again to DC's Office of Cable, TV, Film, Music, and Entertainment, the 202 Creates program. Let me also say thanks to my colleague Stanley Augustin for help organizing and promoting this webinar as well. So with that, Kelly, thank you so much for taking the time to do this, and we look forward to speaking to you all very soon.
Thank you.